Guys, I will be dictating two passages every day, one general and one legal. So subscribe to my channel for latest updates. 5 seconds. This order shall dispose of a bunch of writ petitions which have been preferred by various petitioners. However, the facts have been referred from CWP number 4303 of 2009. The question of law which has been referred to this full bench for decision is as regards the rules which would be applicable to government employees who seek compassionate appointment, whether it would be the rules in operation at the time of death of the employee or the rules applicable on the date when case is considered by the appropriate authority. In view of conflicting views by various division benches, the case has been preferred to the full bench. Some facts necessary for decision of the case are being noticed here. Petitioner's husband, who had been working as junior engineer in Haryana Irrigation Department, expired on 23rd February 1995. On 5th May 1995, she moved an application to Respondent Department for providing employment on compassionate grounds to her only son, namely Manoj Kumar, who at that time was 7 years old. A letter was thereafter addressed from the superintending engineer Narnaul requesting that a post be kept reserved for the minor child of the widow in order to consider his case on attaining majority. In the year 2005, petitioner moved an application that her son be considered for appointment on compassionate ground as he had attained age of 17 years and was going to appear in BA final year examination. She relied upon letter annexure P2 and instructions issued by government dated 27th March 1991. However, application was rejected by the respondents via their letter dated 18th August 2006. The petitioner protested and sent representations. However, stand of respondents remained the same. They communicated to the petitioner that there was no provision for employment under new policy dated 3rd August 2006. Thus, petitioner was at liberty to opt for financial assistance under the new scheme, which would be considered by the department. Aggrieved petitioner preferred the instant petition before this court. In view of number of cases in which similar question arose and there being conflicting views of various division benches, matter was referred to full bench by the single judge. Needless to observe that facts of each case vary. We have noticed facts from one case as referred to above. Policy of compassionate appointment being in the nature of a social welfare department needed liberal interpretation. Thus, the scheme / policy applicable on death of / date of death of the employee should be the relevant for consideration of case of his dependent for appointment on compassionate basis. By same analogy, in case of compassionate appointment, policy prevalent on the date of consideration of application would apply. Observations made by the apex court are as under. Normal schemes contemplate compassionate appointment on an application by a dependent family member subject to the applicant fulfilling the prescribed eligibility requirements and subject to availability of a vacancy for making the appointment. Under many schemes, the applicant has only a right to be considered for appointment against a specified quota even if he fulfills all the eligibility criteria and the selection is made of the most deserving among the several competing applicants to the limited quota of posts available. In all these schemes, there is a need to verify the eligibility and antecedents of the applicant or the financial capacity of the family. There is also a need for the applicant to wait in a queue for a vacancy to arise or for a selection committee to assess the comparative need of a large number of applicants so as to fill a limited number of earmarked vacancies. Obviously, therefore, there can be no immediate or automatic appointment merely on an application. Several circumstances having a bearing on eligibility and financial condition up to the date of consideration may have to be taken into account. As none of the applicants under the scheme has a vested right, the scheme that is in force when the application is actually considered and not the scheme that was in force earlier when the application was made will be applicable. Further, where the earlier scheme is abolished and the new scheme will replaces, it specifically provides that all pending applications will be considered only in terms of the new scheme, then the new scheme alone will apply. As compassionate appointment is a concession and not a right, the employer may wind up the scheme or modify the scheme at any time depending upon its policies, financial capacity, and availability of posts. Before parting with the judgment, however, we may mention that in the present bunch of petitions, facts of each case vary. Since issue referred to this bench has already been decided, individual cases be placed before learned single judge for decision in accordance with law and facts and circumstances of each case.